Hi, everybody. Welcome. Happy Valentine's Day to all of you. My Valentine took me out to an early Valentine's Day dinner last night because I wanted to be here with you all this evening. So, welcome. I'm glad that you're all joining us. Thanks. And we have quite a bit to talk about today. I had a few kind of shuffling my papers, sorry. I had a few of the smaller little kind of um, things that I wanted to talk about because one thing I want to do a little bit of a deeper dive into tonight is whether or not child welfare failed Harmony Montgomery. Now, for those of you who've been with me for a while, you all know I'm a retired criminal defense attorney. I'm writing a book about the Vallow Daybell case. However, I spent 27 years as a lawyer, much of that in doing criminal law, a lot of it as a criminal defense attorney. And about the last 5 years of my career, I did primarily juvenile work. So I represented both kids who'd gotten in trouble, as well as kids, children and parents in cases where children had been removed by child welfare. So abuse and neglect cases primarily. So I'm very familiar with the process in general, although it varies a little bit from state to state. Very familiar with the process in general of how that process works. And so I want to talk a little bit about that tonight because I think there are some important things that we can learn from the things that did or didn't happen in Harmony's case. Now, I told you all I've had a really hard time with this case, and I've been involved in some pretty gnarly cases over the years, and for the most part, I'm pretty much cases the horrendousness of the cases doesn't necessarily bother me. But Harmony's case really hit very, very close to my heart. And here's the reason why. This is little Harmony Montgomery. She was murdered by her father. Um, and she was when she was 4 years old. This is my little demon when she was 4 years old. And you can see the incredible, right down to the thick glasses, the incredible resemblance that she had to little Harmony. And I know that this is one of the reasons why this case just weighs on my heart. That is also her last May at her wedding, but she was that cute little blonde, bespectacled kid, just like Harmony. And so I think that is very much why Harmony's case really touched my heart in a really significant way. So we're going to talk at length about the child welfare case and the way that they managed or didn't manage, more importantly, the issues around Harmony's case. But before we do that, I had a few smaller, not smaller in importance, but a few little snippets of information on some other cases. So I thought I would just run through those quickly, so we'd be up to date on everything before we do our deep dive into Harmony's case. Sarah Boon, now for those of you who aren't familiar, Sarah Boon is the woman who zipped her boyfriend into a suitcase and then went to bed and left him there where he died. He suffocated. She is now her most recent attorney, who was attorney number 7, if you are counting, has asked to withdraw. And she was just appointed lawyer number 8 for those of you who are counting. Now, I do want to make it clear that not all of those lawyers were because they couldn't get along with Sarah Boon. Some of them were because one lawyer was appointed to the bench, one lawyer left the practice. I mean, there were a variety of reasons why her lawyers left. But at least the past several have asked to withdraw because they were unable to get along with Sarah. And the lawyer before this one specifically said that he had to withdraw because she was demanding that he do things that he declined to do. Similarly, this most recent attorney has said, Ms. Boon asked me to do things that were either that I refused to do. Now, that generally means that the lawyer said, I am not going to do anything that is illegal or unethical. So she is pressing her lawyers to do things that they don't believe are proper. So, her case, once again, it has been 4 years since this crime happened, and she is still in custody, and the case has yet to go to trial. Interestingly, the judge didn't set over the most recent trial date, although I suspect that he may. It made me remember a case in Oregon where I practiced. The mandatory sentencing scheme was passed by voter ballot measure. And so we called those cases ballot measure 11 cases. It was measure 11 cases. And those were cases that had mandatory sentencing requirements for the most serious cases: robbery, murder, arson, attempted murder, assault, first-degree assault. All of those sorts of cases carried mandatory sentences. And they generally were very complex cases. And one afternoon, I got called into court, and a judge who was, he was one of my favorite judges. He was a really decent man, very and very on top of things, and had been our presiding court judge for quite a long time. And he called me in and he said, "Ms. Hellis, I am appointing you to this case. It is a very complex assault and robbery case. And oh, by the way, the trial is in 9 days." And I said, "Oh, hold on, wait a minute. Time out, Judge. I'm filing a motion, as you know, I'm making a verbal motion as we speak to set that trial date out." Well, the fellow who was in jail had refused to waive his speedy trial rights. And he kept, because he believed that the judge would be forced to let him out of jail if they couldn't meet his speedy trial rights. And he kept alienating his attorneys, and his attorneys kept withdrawing. And so the judge finally said to him in his very wise voice, "Sir, be careful what you ask for. You might just get it." And so he said to me, "I understand that I am putting you at a great disadvantage, but we will be having a trial 9 days from now." And so I worked like a fiend, and we were as ready for a trial as I could get in 9 days. And we had a trial, and he was, of course, convicted, and then immediately filed an ineffective assistance of counsel complaint and a whole lot of other things. And the appellate court upheld the judge's action and said that given the dearth of time that I had to prepare the case, I had done a more than adequate job, and that I was in no way ineffective, even with 9 days. But that was the craziest case I ever had, where a person kept asking them, a judge for different lawyers. And I don't know that it had anything to do with me personally. I think it was just the luck of the draw. And then when I walked in, the judge said, "You're going to try the case in 9 days." So it happens. And I think it is interesting that at this juncture, the judge has not continued Sarah Boon's trial, because it does appear at this point that she's playing games. And it's hard to say. It's clear that she's very demanding and that she has very, her expectations are just not within the realm of reasonable. So she's got these very unreasonable expectations about what her lawyer's going to do for her. And it appears that she is demanding that her lawyers do things that are either they either feel are illegal or are unethical. So I'm going to go over quite a few of these cases, and then we will take questions. Now, I know that Jen is flagging questions in the chat as we go, but if you want to be sure that your questions get answered, please hang on to them for a little while and wait until we ask for the question time, because that makes it easier for Jen, who's our moderator, to flag those questions. It's much easier to find them and post them when they're all sort of in the same area than it is when she's trying to scroll through the entire chat to find them. So jot them down and be ready to post them when we ask for questions, because that makes it much easier for Jen to grab those. So there's a couple of things going on in Bryan Kohberger's case. Bryan Kohberger is the person who has been charged with the deaths of 4 college students in Moscow, Idaho. And there have been several things going on. There's been an ongoing dispute between the sides having to do with the genetic genealogy and DNA results. So the prosecution originally resisted the idea of having to turn over all of their genetic genealogy information, saying that it really only amounted to a tip. However, the judge did review that information in chambers, in camera, as they say, and did order that some of that information be turned over to the defense. So the judge also issued a order sealing a lot of that information, and now the prosecution is asking for some clarification on the judge's order. I don't know really what that's about. However, there is a hearing coming up on February 28th at 1 o'clock that will be open to the public. Some of those hearings have been closed because the information was confidential. So as things go along, I think we'll know a little bit more. The other big thing that happened in the Kohberger case was the defense has filed a motion to change venue. I don't think that's at all surprising. Moscow is a small community, something to the akin of Rexburg, and it has struck me from the beginning that they were going to have difficulty seating a jury in that location, that it would be easier to seat an unbiased jury in the Boise area. The prosecution promptly objected, just like they did in the Vallow Daybell case, and I think the court probably will agree to change the venue as they did in the Vallow Daybell case. So that will be happening moving forward. Speaking of Vallow Daybell, just realized I haven't closed my office door, and my dogs are running up and down. So just so it stays quiet while it's just us, wanted to close that door. Sorry for that. These lovely posies here that are in behind me were from my Valentine. So the next thing I wanted to talk about is a couple of small developments in Vallow Daybell. You probably all have heard that Rachel Smith is off the case. I don't think that was any huge surprise. Rachel Smith was brought on because she's an experienced attorney who has tried murder cases, including death penalty cases, and she was brought in to help and to advise in that regard. Once Lori's trial was over, I think she had probably done as much as she could to help the prosecution get ready for a murder prosecution. And I never got the impression that her fees were all that they're not nominal. Let's put it that way. My recollection is she was making between $6,000 and $10,000 a month as an advisor. And that's a lot for a small community to come up with on a continuing basis. We've talked before about the incredible cost that this trial has had, the incredible burden it's been on a very small county, population-wise, a small county. So the Fremont County prosecutor, Rachel Smith, was originally hired by Madison County, by Rob Wood in Madison County. That's where Rexburg is located. When the charges came out against Chad Daybell, his property was just a few hundred yards inside the county line for Fremont County, so the next county over from Madison County. And so the murder charges really were brought out of Fremont County. However, it was Madison County who brought Rachel Smith in as a special prosecutor. So Fremont County felt like they couldn't continue to have her on the case. Interestingly enough, though, she very promptly was hired by Canyon County, Idaho, to help with the Jeremy Best case. For those of you who might not be familiar with that case, it happened fairly recently. Man, very severely mentally ill, broke into his ex-wife's home, killed her. She was pregnant, so killed her and her unborn child, and took their year-and-a-half-old child with him and disappeared. Police later found him in a sleeping bag by the side of a very remote road in a very remote location. And the baby was deceased inside his pickup truck. So very sad case. And Lori Vallow's former lawyer, Jim Archibald, was recently appointed to represent him. So it's a thorny case because it's definitely a case where there's some serious mental health issues. This is a man who had a history of severe mental health issues. So that one's going to continue to wind its way through the system, and it's going to be a complex and pretty gnarly case. So they brought Rachel Wood on in that case. The other information is that they're still waiting for the clerk of the court and the court transcriptionist to finish the transcripts of Lori's trial to go forward with her appeal. So her appeal is really sort of on hold right now until all of that is done. And as we talked, creating a word for word transcript of a trial is very labor intensive. And so it could be some months really before that is finished. I also noticed that Lori's Arizona trial, I am going to attempt to share my screen with you, provided I can find it. Well, here it is. I'm trying to get better at this, at these audio visual things. This is the sentencing order for Lori, and I certainly am not going to read the whole thing. If you guys want to pause it, you can pause it and take a look at it. But the interesting thing is that it does say the trial date. It does say, first of all, that the trial is if you look down about halfway down, there's a single line there, and it says last day 9/2/24. That is the latest day at which the trial could start because of her speedy trial rights. It also says that trial date shall not be continued unless written motion to continue is filed with the master calendar assignment judge. And it also says affirming the trial assignment date on 8/1/24 before the master calendar assignment judge. Now, I am not clear whether that is actually a trial date or not, because it says trial assignment. It may be that that is the morning that you appear and they tell you who your judge will be. Because in a lot of larger jurisdictions, you appear for trial and then you don't know what courtroom you're going to be in until that trial assignment is done at the master calendar session. So that may be what it is. It also says the purpose of the hearing is to set dates for the trial procedure conference and the jury selection date. So somewhere around the 1st of August, we're going to get Lori Vallow to trial on the Arizona charges. So, and the other thing that I did want to talk about is, now I have to rearrange my screen here. The other thing I wanted to talk about is a development that's happened in this last week or so. And I know that there are a lot of you who follow all of the creators who have anything to do with Vallow Daybell, including a couple of members of the family who have their own YouTube channels. Now, I have said from the very beginning, no one knows what it's like to be a family member of a murder victim. None of us could ever, who haven't experienced that, could ever put ourselves in their shoes. And I don't believe it's fair to pass judgment. But what I will say is one of the family members has recently put out a video going after another family member. And one of the things that I was asked was, if the family member who's being accused made false statements while they were testifying in Lori's trial, would it be perjury? And the answer is no, because in order for something to be perjury, it has to be material to the case. And the issue that came up is not an issue that was material to JJ's murder or anything having to do with Lori Vallow's innocence or guilt. It was an entirely separate and really collateral issue. I know I'm kind of speaking in code, so those of you who don't know what's going on are going, "What the hell is she talking about?" But on the other hand, I have never wanted to get involved on that granular level. I absolutely refuse to go after any member of the family, and I believe that we as supporters and people who are seeking justice for victims need to grant them grace and understand that thankfully we will never know what they're going through. So I don't want to get deeply into the she said sort of back and forth thing that's been going on. What I do want to say is please support the victims' families in whatever way. I cannot in any way support or take a position that would make them that would put me between putting them against one another. So I only want to answer the question, which several people have asked me about whether or not the family member who testified could be charged with perjury, and the answer is no. Prosecution for perjury can only occur if the thing that was said on the stand is actually material to the case. So hopefully that answered y'all's question and put all your minds at ease. And hopefully I didn't get too deep into it because that's absolutely not where I want to go. I want to talk about Delphi because the shit show continues. The prosecution filed a motion to hold Richard Allen's recently reinstated lawyers in contempt for what he claims is a violation of the court's gag order. And it's fascinating. First of all, contempt is a strange, it's a funny charge because it's sort of like semi-criminal. Okay. Bear with me here. There are a couple of different kinds of contempt. Now in Indiana, they say there's essentially in-court and out-of-court contempt. But in most states, they also differentiate whether a contempt is civil or criminal. And the difference is that in a criminal contempt action, the person who is seeking to have the other person held in contempt is asking for a criminal penalty, such as jail time. Otherwise, the action is a civil action. The finer points of this appear to be something that the prosecutor is not that familiar with. Not that surprising, because contempt is not something that comes up in prosecution very often. And it's sort of a pseudo-criminal action. So the prosecution wants to hold Baldwin and Rosie in contempt for violation of the court's gag order. But the demand that they have made, the filing that they have made, the information that they filed is absolutely defective. First of all, you don't file a contempt in the action, in the associated action. You have to file a separate contempt case. And they didn't do that. The other thing is that you have to allege that the contemptuous conduct was willful. And finally, you have to tell the judge whether you're asking for civil remedies or criminal remedies. And the prosecution has done none of those things. So interestingly enough, the prosecution then filed a motion a demand actually for discovery. Now, the prosecution claims that they're entitled to discovery because it's a criminal case under the same Brady v. Maryland standards. But that's not at all the case, because a contempt case does not fall under Brady versus Maryland. So now that the prosecution is saying, we gave you a list of all our witnesses and all the evidence we were going to present, we want reciprocal discovery. And Baldwin and Rosie's attorneys are saying, no, we don't have any obligation to give that to you. This is a civil case. Welcome to trial by ambush. So really interesting, because I think this prosecutor is way out of his depth. They now have a new lawyer who has filed the response to this, to the contempt action. And I think it is going to be very enlightening to see what the judge does about this, because I think that their argument is pretty clear cut, that they don't have a basis for a contempt, that there is not a legal basis for a contempt. If the judge allows this contempt action to go forward, I think that is going to cement their argument about her bias. Because there's, if you can stand there and say, the prosecutors have filed what is essentially a frivolous action, and the judge is so biased that she would not even see that frivolous action as something that should be dismissed, then I think we're getting into some ground that they would have a good action to maybe continue to get Judge Gold disqualified. However, that's very complicated. So I want to get into that in a minute. But then Baldwin and Rosie turned around and filed motions to dismiss the case completely because the plaintiff was negligent and failed to preserve evidence. Now, what happened in that instance was, about 3 days after the girls were murdered, the two people who Baldwin and Rosie believe were involved and are connected to this Odinist group were interviewed by the FBI. And those two guys gave interviews. The FBI gave written reports. As in every written criminal report, it says this is not a word for word verbatim record of the interview. For a more complete, for the complete interview, see the tape. So when Baldwin and Rosie requested the tape, the prosecutor finally, just recently, had to admit that those had been overwritten and were no longer available. So it will be interesting to see what happens. I think it's very likely that Judge Gull is going to say, no harm, no foul, because you have the written reports of those interviews. I certainly think that would be will be an appellate issue if Richard Allen ever gets to trial and is convicted. But here's the issue about disqualifying Judge Gull. And I want you to stick with me here, because I'm about to get a little bit in the weeds. So when Judge Gull removed Baldwin and Rosie from the case, they then attempted to file motions to get reinstated, to disqualify Judge Gull, all of which she absolutely refused to docket because she said they no longer represented Richard Allen, and refused to allow those documents to be filed. So that meant, now in a typical trial, if you get a ruling from a judge that you don't believe is right and want to challenge, you do that by asking for an interlocutory appeal, meaning that you ask leave of the court to appeal to the appellate court on that specific issue. Interlocutory appeals are generally only granted when it's something that could have an impact on the ultimate outcome of case, because interlocutory appeals put the case on hold while the appellate court makes a decision. So it's an interim, it is a pretrial, an appeal of a pretrial order. Once the case goes to trial, then you can appeal anything that you raised during the trial after the outcome of the trial is decided. So anything that was raised either pre-trial or during trial can be appealed to the appellate court after the case is finished. Interlocutory kinds of appeals are because you believe that your client is going to be damaged or their due process rights are going to be impacted if you're not allowed to appeal that before the case is tried. So that's what happened with Rosie and Baldwin. They wanted to file an interlocutory appeal on the issues that Judge Gull had denied. But Judge Gull said, oh, no, I'm not going to let you file anything in this case because you're no longer on the case. Now, there is a way that if you cannot get an issue dealt with by the Supreme Court, you can request that the Supreme Court take your motion as an original action, okay? So it means that you're filing your own original case directly with the Supreme Court because you can't get relief in the underlying case. For whatever procedural reason, relief isn't available to you, as it wasn't to Rosie and Baldwin. So because the Supreme Court recognized that that was their only recourse, they took up that case, and they took it up very quickly, and they reinstated Rosie and Baldwin. So now Rosie and Baldwin are back on the case. Now they're talking about, well, they filed another motion to recuse Judge Gull. She denied the motion. They filed several other motions Judge Gull has denied. So how did they get, and the other terrible quirk about Indiana law is that the judge who decides whether or not they're biased is the judge. In a lot of jurisdictions, that decision would go before the presiding court judge or some other judge who would determine whether or not there was ample evidence that a judge was biased. Now, I'm here to tell you that in most cases, a judge is going to recuse themselves the instant somebody raises the issue of bias because they don't care. They're like, I got 100 other cases I can try. I don't care. If you don't want me on this case, that's fine. Let some other judge take the misery. So it's unusual for there to be a contested recusal or disqualification. However, Judge Gull has been adamant that she's going to stay on the case. So where does that leave Baldwin and Rosie? Well, they have to find a way to appeal her decision. So the first thing they have to do is they have to file an interlocutory appeal. But in yet another quirk, they have to file a motion with the trial judge asking for leave to file an interlocutory appeal. And if they're denied, then they can file an original action with the Supreme Court saying that they have no other recourse because she has denied their motion for interlocutory appeal, has denied their motion to recuse herself. Now, I am not sure that the Indiana Supreme Court is going to take up an original action motion the way that they did on the issue of reinstating the attorneys, because I think they're going to see that as an appellate issue that can be appealed after the sentence, after the case is over. I think that Baldwin and Rosie are going to argue that there's no way for Richard Allen to get due process as long as Judge Gull is on the bench and is making these decisions and is as blatantly biased as she is. So it'll be interesting to see. These are the kinds of procedural wranglings and some of the other that lawyers nerd out over. Now, if you're really interested in those aspects of Delphi, definitely tune in to Defense Diaries with Bob and Ali Mata, because they're both lawyers. They are in Illinois, so in a neighboring state. Bob Mata has been covering this Delphi since the very beginning. He drives to all the hearings, so he's really up on it. And he and Ali have had lengthy discussions. There's a lot of stuff in their playlist about these issues and how these appellate issues are being handled. And it's really interesting. I geek out over it, but it's definitely in the weeds. So, and then finally, I want to talk about harmony and the child welfare system. Because I think there is ample evidence, and actually there's a report, there's ample evidence that the state of Massachusetts let harmony down in this case. So before we get sort of deeper into the specifics of Harmony's case, I want to talk a little bit about how the child welfare process works. And it's pretty standard in most states. So I can tell you in general the way it works. Small specifics and nuances, our timelines, those sorts of things will be a little bit different from state to state. So what usually happens is a report comes in to child welfare, to their hotline or through a person who is a mandatory reporter, that there is a suspicion that a child is being abused or neglected. Child welfare sends an investigator along with a police officer to the location where the child is. They sometimes interview children at school if the child is a school-age child, but they go out to the home where the child is located and they investigate whether or not there are conditions exist that pose a threat of harm to that child. If the child welfare worker and the police officer, the law enforcement officer, believe that the child is at risk, they remove the child from the parents and in an emergency shelter situation. So within a very brief amount of time, usually 24 to 48 hours, all of the parties, the child welfare investigator, the parents, everyone has to appear before a judge who reviews whether or not there is evidence to believe that there is a threat of harm to the child. It's similar to a preliminary hearing or a grand jury hearing in a criminal case to assure that there is a basis in fact for the concerns that have been raised about the child's welfare. What then happens is it's set for an admit or deny hearing where the parents have one of two options. They can come into court. They can admit that the child is within the jurisdiction of the court because of their abuse or neglect. And if they do that, then the state is required to work with them to rehabilitate them and to cause their home to come up to minimum adequate standards. Now, understand that minimal adequate standards is a very low bar. It is not something you and I would want our children to live in. But it means, are they adequately supervised? Do they have adequate clothing, food, medical care? And is it minimally adequate? These are not homes where children these are not optimal conditions. They are minimally adequate conditions. So the children can be placed in foster placement, or if there is a family member, they may be put into a family foster care situation where they place the children with a family member who is suitable and can be certified as a temporary foster placement. The preference in most states is to place children with family members if that's possible, if there is a safe and appropriate family member for the child to be placed with. At that point, then, the parents begin working. The child becomes a ward of the state if the parents admit that the child is within the jurisdiction. If they deny it, then the court will hold a hearing and the state will put on evidence to show that the parents are abusive, neglectful, whatever the criteria is, and that their behavior presents a risk of harm to the child. So once the child's in foster care, a clock starts to run, and the parents have a fixed amount of time. It varies a bit from state to state of how many months they are permitted to get their acts together, to get drug and alcohol treatment, to find adequate housing, to find employment, all of those things. One of the most difficult bars, often in recent years, has been housing. Affordable housing is so awfully difficult to find, and it's even more difficult if you are a person who has a criminal history. So people who have felonies on their record, it's nearly impossible to find housing. So the parents are tasked, they're given a checklist, and these are the things that you need to have accomplished before your child can be returned to you. They're also cautioned that if the child is not returned within a reasonable amount of time, usually about 12 months, the state will move to terminate their parental rights, and the child will be placed for adoption. For those of you who are familiar with the Vallow Daybell case, this is what happened with JJ's parents. They were unable, after the allotted period of time, they were unable to accomplish the things that were required of them and to get themselves into a position where they could adequately parent JJ and safely provide him with minimum adequate standards. So, and that is what happened with Harmony. Harmony was 2 months old when she was removed from her parents, her mother, because her father, Adam, was in prison. She was removed from her mother because her mother was not able to appropriately care for her. Her mother, Crystal, had a very serious drug problem, and there were very real concerns about the safety of Harmony as a 2-month-old. Now, the other thing I want to talk about in general before we get into the specifics of Harmony's case, because it becomes an issue as we go along, is something called ICPC. So in the federal government, if there are issues that span state lines, the federal government gets involved by asking the states to adopt a uniform policy. So there's a uniform Child Custody and Jurisdiction Act. So for non-child welfare, child custody disputes between states. There's also a uniform act that handles how child support is collected across state borders. In this case, this is called the Interstate Compact for the Placement of Children. And this is an agreement or an agency that has to approve anytime a child who is in child welfare's jurisdiction is placed out of state, because the receiving state has to do a um, has to do an analysis and an investigation before they'll receive the child placement, because they're already under the jurisdiction of the sending state. So we'll get into that, because there's a real question having to do with ICPC, Interstate Compact for Placement of Children, between Massachusetts and New Hampshire. So the next thing that happened with Harmony was that she was placed with a foster family. When she was placed, it was clear that she had some fairly significant health issues that she was born with. She was blind in one eye, and that had some other impacts, very likely because of her mother's drug use while she was pregnant with Harmony. When the foster parents received Harmony, they were told that she had very severe brain disorder as a result, and it was unlikely that she would live past about 7 months. But foster mother realized that something was not right about that diagnosis, that they originally told her that Harmony was completely blind, but she noticed right away that Harmony was following her with at least one of her eyes when she was feeding her. So continued evaluation as Harmony developed revealed that, in fact, Harmony was of normal intelligence. She was not developmentally delayed. And although she was blind in one eye, she was well able to function. And her foster family quickly fell in love with her. She was just a little bright spot. During the time that the foster parents had Harmony, there were a couple of different attempts to reunite her with her mother, and they didn't go so well. In the meantime, they also facilitated visits with Adam while he was in prison. Child welfare made sure that they took Harmony to visit him while he was in prison. At some point, Adam got out of prison. Harmony's mother, Crystal, had still not achieved what she needed to achieve in order to have Harmony returned to her. And the case, unfortunately, Adam got out of prison, and he immediately began pushing to have Harmony placed with him. So there's a really interesting document. I'm going to share my screen again. And I'm going to pull up. Hang on, I have to get closer here so I can see my list. I'm going to pull this document up. Now, I linked this document in our show notes, and I'm not going to read the whole thing, but I am going to summarize it for you. So I just want you to know it's out there. It is on the state of Massachusetts website, and I put the link in our show notes. So if you want to go through and read the entire document, you can. So, but I am going to summarize the findings, because this was an investigation that was done by the Massachusetts Office of Child Advocates. And they did an investigation, and this report was dated May of 2022. So the findings that they made were fairly critical, to say the least. But they do sort of explain for us where things went wrong. The first thing they said was that the case focused only on Crystal, Harmony's mother, because Adam was in prison. He didn't engage in any of the services while he was incarcerated. He didn't do any engagement other than to do the facilitated visits where DCF facilitated Division of Child Welfare, facilitated the visits, but he didn't do any assessments. He didn't wasn't referred to do services, no investigation of his family or his personal history, and no action plan was made for him. So they didn't treat him the same as they did Crystal. And when he got out of jail, he immediately started going to court and demanding that Harmony be returned to him. The second finding was that Harmony's medical and social needs were not central to the decision-making that was done in the during the 2 times that she was reunified with her mother. And because of that, the placements were disrupted. Her placement was very unstable. She was back and forth, and that caused trauma for her. And that trauma was not taken into consideration, and her needs were not prioritized in the case regarding her care and safety. So she spent a total of about 40 hours during 20 supervised visits between the time she was 2 months old and age 4 with Adam. There was no placement. There was no plan for a safe transition for her. She simply was turned over to Adam. The biggest issue was that Adam lived in New Hampshire, and the state and the DCF, the state's attorney, didn't present a strong case because DCF had not investigated Adam. They weren't able to present to the court the issues that Adam had or address his ability to meet Harmony's specific needs. No ICPC investigation was raised. Typically, what would happen is that the interstate compact would be activated and the receiving state would be asked to open a case having to do with the child so that they could continue to supervise the transition from back home to the parent. In this case, for some inexplicable reason, the state agreed not to move forward with an ICPC action and instead to simply dismiss Harmony's case so that there was no one overseeing the transition from foster mom to Adam. There was no consideration that they would return her to Crystal because Crystal had already proven that she wasn't prepared and ready. But I think a lot of it had to do with the fact that Adam went to court and said, I have this great new wife and she's a good caregiver and we're moving into this house. And he was able to paint it as a sense of stability. And instead of activating the ICPC system and getting the state of New Hampshire's child welfare to pick Harmony up on their caseload, Massachusetts simply returned Harmony to her dad and dismissed the case. And there was no further oversight, over Harmony and her case. To make it worse, not only did the state of Massachusetts, the state attorney and the Division of Child Welfare completely abrogate their responsibilities, but Harmony's attorney didn't present any evidence of her needs or talk about whether or not Adam was a suitable placement. They simply agreed that Harmony be placed with Adam, didn't insist that there be an ICPC action or that the state of Massachusetts not dismiss their case until she'd been picked up by New Hampshire. And the attorney knew that DCF had never conducted an investigation into Adam, didn't require, and unfortunately, the standards for the attorney that was court appointed, the public defender standards, didn't require, under the Massachusetts standards of practice, that the lawyer do that. Now, I've looked at the Massachusetts standard of practices, and it's clear that they have tightened up their practice standards since this case happened 2 years ago, because they now require that the lawyers do a lot more training, and that they jump through a lot more hoops, and that they clearly advocate for children who are unable to advocate for themselves. Now, I will say that there's always a split of opinion when it comes to representing children. In general, a lawyer has an obligation to seek the outcome that their client wants, regardless of whether the lawyer agrees that it's in their client's best interest. But that presumes that their client can make those decisions, that they are mature decision makers. When you represent a child, there is a split of opinion about whether or not you as a lawyer have an obligation to advocate for what your client wants, or to advocate for your client's best interest. Now, in my home state, the practice standards do say that a young child, when the child is young, the lawyer has an obligation to advocate for the child's best interests. It gets a little gray when you get a child who's 10, 11, 12, and who's advocating, I want to go home to my dad, when you know that dad is not ready to have that child, and that you know that is not within that child's best interest. It's a sticky and difficult place for lawyers to be in. This is why a lot of lawyers don't care to do child welfare cases, because they feel like the guidelines are not black and white enough about what the expectation is going forward. But it's important to know that regardless of the behavior of the lawyer, which I would say left a lot to be desired, the state and child welfare's lawyer, who's essentially child welfare's prosecutor, has an obligation to make sure that a child is safe before they return that child. And none of that was done, because no investigation was done into Adam Montgomery, who he was, any sort of assessments about his fitness as a parent, any examination of his psychological or even his criminal history. And my understanding is one look at his criminal history would have raised some serious questions about whether or not he was fit to parent Harmony, and whether or not he was potentially violent. So the system really let Harmony down. In addition, after Harmony was already in New Hampshire with her father, child welfare was alerted that there were concerns when an uncle saw her with a terrible black eye, and Adam admitted he beat her. And the uncle reported that to child welfare, and child welfare went to check on Harmony. And when they arrived, Adam went out the back door with her, and they never followed up on it. So New Hampshire was complicit as well in not protecting Harmony. But had the state of Massachusetts required that an ICPC study be done, and that Harmony be picked up by New Hampshire child welfare before they allowed her to go with Adam, I think there would have been much more oversight, and she may have been much more on New Hampshire's radar. So it was a failure all the way around of all of the child welfare agencies. And it appears that both states have now sort of tightened up their rules and their regulations. It's incredibly unfortunate that it took the death of this beautiful little girl before they did something to tighten up those regulations. Harmony's case is absolutely heartbreaking. It's heartbreaking that she was missing for nearly 2 years before they really even started to look for her. And it wasn't until Kayla Montgomery, Adam's wife, made some admissions that that they really started to look for her. So it was an incredible failure of the system. And, you know, it is not anywhere near a perfect system in any state. Some states are better than others. I don't really know about Massachusetts or New Hampshire, but I can say that in this case, they both dropped the ball horribly and tragically. And, you know, there is always a tension in these cases because we do believe that, and mental health professionals tell us that even if parents are less than optimal, it's still better for the children to be with them than to be separated from them. So we're always walking that tightrope of how bad does it have to get before we actually remove a child from a parent. There are a lot of cases where child welfare comes in, leaves the child with the parents, but requires them to do treatment and services and those sort of things, attempting to keep the child in their home and come alongside the parent and give them support. And sometimes that works and sometimes it doesn't. And it's always a tightrope. It's always a very difficult choice. And I want to point out that just like there are a shortage of public defense attorneys, there's also a shortage of child welfare workers. They don't get great support. They deal with horrendous caseloads. They deal with horrendous cases. And they don't get enough support, and they are also very underpaid. So it's really hard to keep child welfare caseworkers. They don't receive a lot of emotional and psychological support for themselves when they're dealing with these incredibly traumatic situations, and they're not paid well. They're constantly asked to do more with less, do more with less, do more with less. And unfortunately, that leads sometimes to these outcomes. I don't want to justify that because I don't believe that there's any way to justify a single child losing their life or a single child being exposed to such heinous circumstances. So I can't make excuses because I don't believe there's ever an excuse for it. But I will say that it's not a simple problem to fix. It's not a simple problem to fix because the resources simply aren't there. And it is a frustration that in a world where there are many, many competing interests for tax dollars, it is often the case that the loudest voice gets the money and not the neediest voice. So I think we're ready to take some questions. If you're ready, I'm ready. So if you haven't already, please post your questions in the chat and Jen will pull them up. I see that she's got some questions starred already. She usually tries to group them by case so that we talk about the same case at the same time. Hi, Greg W. How can the judge not require Adam be in court for his own trial? Let me answer that. It varies from state to state, again, because we have this pesky constitutional 14th Amendment that gives sovereignty to states. So it is a little bit different from state to state. And judges do have do have some discretion. For whatever reason, this judge has said, I am not going to issue an order physically requiring the sheriff to hogtie him and bring him to court. That is a decision that the judge makes. It may very well be because this is a very high profile case, and she really doesn't want the optics of having Adam Montgomery shackled and hogtied and brought into court in a wheelchair or on a stretcher. And it's not a good look. And I think the judge feels that it wouldn't serve any purpose. He has already admitted to 2 counts in the indictment having to do with destruction of evidence and abuse of corpse. But he is claiming that he didn't end Harmony's life, that Kayla did, which seems a little hard to believe. Now, do I believe that Kayla is responsible and bears responsibility for the fact that she didn't protect Harmony and that she didn't report Harmony's death? Yes, I do. But I want to point out that there's ample evidence that Kayla was an abused woman, that there's ample evidence that she was traumatized and a victim of abuse herself, and was afraid to the point where she was not going to put herself and her 2 young children at further risk because of Adam's volatility. I don't know that that excuses it, but and she certainly has to live with what she did. However, I think that if you talk to people who are experts in trauma and who are experts in battered women's syndrome, they will tell you that it is not at all uncommon for people to do things like Kayla did. So I don't know at this point that it's within if I understand enough about the case and enough about the dynamics between Kayla and Adam to be able to say she was at fault. But so this judge has decided not to force Adam to come into the courtroom, and we don't know yet. The prosecution is pretty much just wrapping up their side of the case. Once they rest, we don't know whether the defense is going to put Adam on the stand or not. I think it would be very counterproductive for them to put him on the stand. But as we've talked about before, the ultimate decision on whether a defendant testifies or not remains with the defendant, which is why we saw Alec Murdaugh testify and why we saw a couple of other people recently testify. So it ultimately is their decision, even if they're being told by their lawyers. I don't think it's a good idea. So we don't know for sure whether Adam will testify. So good question, though. I have never seen a case where in my jurisdiction where a defendant has refused to come to court, but I know it happens. Can Kayla's immunity be revoked? Hi, Bo Peep. Yes, immunity can always be revoked. And typically, immunity is revoked if you have lied under oath on as to a material issue. Okay. Once again, it has to be material to the case. You can't lie about, yes, I brushed my teeth when I didn't, because that doesn't have any relevance to the case. So it has to be a material fact. My understanding is that Kayla lied to the grand jury. When she was offered immunity, then she agreed to tell the truth. So her immunity wouldn't be revoked because there was a difference in what she told the grand jury and what she said at trial, because the immunity agreement didn't happen until after she testified at the grand jury. And she freely admits that she was not truthful at the grand jury. So it could be revoked, although I don't know that she's done anything during this trial that would raise to revoking her immunity deal. Hello, Jane Blackbird. I'm sure you remember the Hart family, foster family that had a tragic ending, made me question the lack of interstate communication between agencies. Interstate, I don't remember the Hart family right offhand. I do remember a couple of foster families in the state of Oregon when I was still practicing, where there were allegations of abuse and neglect. But the interstate, the ICPC, the Interstate Compact on placement of children, has been around for a very long time, for 20, 30 years in some form or another. And it does require that if a child welfare agency is placing a child in an out-of-state placement, they're required to go through that ICPC system. Now, what we know about ICPC is it's a little cumbersome and it takes time. And if you have a case that you're trying to wrap up really quickly, an ICPC investigation is not going to allow that. However, in a case like this, where you actually have a parent that you're advocating placing a child with who has had zero investigation, it's absolutely negligence not to activate that ICPC process. Instead, what they did was simply dismiss the child welfare case and let Adam take Harmony to New Hampshire, because there was no bar against it. So it was very unfortunate. They should never have dismissed the case and just simply allowed him to go on his merry way. It was a huge and tragic error. But unfortunately, there's no way for the state of New Hampshire to know that Harmony had come into their state until they got a hotline report of new abuse or neglect. They didn't know Harmony was coming into the state with a pending child welfare case. The Hart family. Okay, now I know, Jane Blackbird. The Hart family from Vancouver, Washington. They were driven off a cliff by their foster moms. The children were from different states. Yeah. So I don't know in the Hart case. I do recall the case now. I don't recall in that case whether there was an open child welfare case for all of those children, but I suspect there was. My recollection is that although they were from other states, they had been transferred using ICPC. So the receiving states, the receiving state of Washington, if I recall correctly, some of the children were placements from Oregon. Now, Oregon and Washington are directly across the border from one another, and Vancouver, Washington is literally like a bedroom community of Portland, Oregon. Like a lot of states, sometimes you have a metropolitan area that spans across a state line. In Oregon and Washington, in the case of Oregon and Washington, it is not at all unusual for people to live in Vancouver, Washington, where taxes are lower and property prices are lower, and work in Portland, Oregon. So it may very well be that those children went back and forth from Vancouver to Portland would be across the state line. I would be very surprised because I think there were open child welfare cases. So I would be very surprised if an ICPC action hadn't been taken before the kids were moved over to Vancouver, Washington. But, you know, it certainly is never a complete protection against a rogue parent or a rogue foster parent. I mean, look at the Powell case. A child welfare worker took the children to visit their father for a supervised visit. She knocked on the door. The dad pulled the two little boys in the house, shoved the child welfare worker out the door, slammed the door, murdered both children, and blew up the house in a matter of seconds. As the child welfare worker was standing on the front porch, he had filled the house with natural gas and lit a match. So, you know, even the most careful plans can go awry with a rogue parent or a rogue foster parent. But certainly we hope that child welfare is going to pick up hints of that before, if it's a case where they're monitoring the transition and assuring the child's safety. I suspect that had ICPC been activated and the state of New Hampshire opened a case with Harmony, that they would have monitored that transition. Now, I can't say whether Adam and Kayla would have presented well enough for long enough that they would have closed the case, but I kind of doubt it. And I suspect that had the state of New Hampshire opened a case for Harmony, that they would have been monitoring that transition and would have discovered the deficits in that house. So good questions, guys. Shelley's Flowers. Question: was there any chance that the foster mother could have hired an attorney to follow up due to Adam's incarceration and being a career criminal? This is a good question. And I had more than one foster family come to me and say, I have been ordered to return a foster child. I have deep reservations about the biological parents. I am very seriously concerned about the safety of this child, and I need help. And the truth of the matter is, there is not a lot of recourse for foster families, and certainly not across state lines. It's an unfortunate reality that foster parents often have virtually no rights. And that is a really hard place to be when you have established a relationship with a child that sometimes lasts years. I have nothing but absolute admiration for people who foster children. I don't think I could foster animals, let alone children, because we used to joke in my office that at least once a week, I would look at my assistant and I would say, "What is wrong here? Just give me the frickin' kid. Just give me the kid." There were so many times over the years that I thought, oh, there's so many other options that would be better for this child than where they're at. And child welfare work is some of the toughest work that any of us do. Lawyers, child welfare caseworkers, law enforcement. I mean, they are tough cases. And I'll tell you quite honestly that by the time I had a caseload of over 100 children, sometimes on my caseload, I was, for 5 years, I was ready to retire. It's hard work. So, and I admire all the people who step up and do the hard work, because the kids in the world out there need them. Which reminds me that there is, you can hang on to that question, Jen, and I will get to it in just a second. But I want to tell you that there is a national organization called Court Appointed Special Advocates, CASA. If you get a chance and you have any interest in supporting children who are in foster care, Google them. There is a branch in every state, and they are volunteers who are appointed by the court to be legal parties in the case and advocate for the child. And they are not bound by the same obligations as a defense attorney. We talked about the fact that when a child reaches a certain age, a defense attorney may be obligated to advocate for what the child wants, even if that person knows in their heart that it's not what's in their client's best interest. Now, there are certainly ways to telegraph that to a judge. There are certainly ways to communicate that to a judge, to say, Your Honor, my client has directed me to communicate to you that they want to live with X parent. There are very sort of prescribed, coded sort of responses in trial that do their best to communicate to a judge that as an attorney, you have an ethical obligation to advocate for what your client wants. However, this is a child whose brain isn't fully formed yet, finished, and it may not be in their best interest to do what it is that they want. So there's always that tension. When you have a court-appointed special advocate, that advocate's sole responsibility is to advocate for that child's best interest. Doesn't have any of those constraints. So if you are somebody who is interested in that, I will put a link to the national organization in our show notes. I just thought of this. And I would definitely encourage you to look into, they do trainings, they train you to be an advocate for the child. The other beauty of it is you only advocate for one child. You are a CASA for one child. So where the lawyer has 100 kids on their caseload, or the child welfare caseworker has 20 families on their caseload, you only have one child. And you form a relationship with that child, and you form a relationship with all the rest of the people that are involved in the case. And court-appointed special advocates are incredibly important. So any interest in that? And if you have any questions, post questions in the comments, and I'm happy to answer them having to do with that program. So think about that. Because they do have branches all over the country. In every state, there's a court-appointed special advocate group. So now ready for the next question, now that I've digressed. Hi, Kathy Crosby. Have any of the agencies and people been sanctioned? They should be fired, or at very least, I'm new to the case. You know, I don't know, but I do know that this report that was filed by the Office of Child Advocate, which is a government agency, and that they filed this very scathing report and made some pretty clear recommendations. So I would be very surprised if people had not been sanctioned. I think that the ball got dropped in the state of Massachusetts, and that they had no business not insisting that New Hampshire, that they use the ICPC process, and that New Hampshire open a case and monitor the transition for them. So, you know, but it's also interesting because I don't know the dynamics of the neighboring states. So in where I practiced in Oregon and Washington, we used to, because I practiced for some period of time in Portland, it was not unusual to have ICPC kinds of arrangements back and forth across the state line. And our ICPC agencies were pretty cooperative, but I don't know whether what the history is of ICPC between New Hampshire and Massachusetts. So that could have a bearing on it as well. So it would be interesting to delve a little bit deeper into it. All I know at this point is that this report has been filed. It is posted on the massachusetts.mass.gov website. So it's clear that Massachusetts is taking responsibility, and I would assume taking remedial action as a result. I think it would be shocking and probably they would be inviting lawsuits if they admitted and posted that they had fallen short in this case and then turned around and didn't do anything to remedy it. So I'd be quite surprised. Questions: after trial, can she be charged for the murder of Harmony? I don't believe so. First of all, I don't believe that there is any probable cause to believe that she was directly involved in Harmony's murder. She has made very clear that she was involved in the cover-up and has been granted immunity for that in exchange for her testimony against Adam. But I certainly have not heard or seen anything during the trial that would suggest that she was more involved in helping cover up. I mean, what she did was heinous, helping him move the body, helping him cover up and dispose of Harmony's body. It was heinous. But the state believed that they had the responsible party, and believes that that her testimony was important enough to give her immunity from prosecution. So she has immunity from prosecution to in the abetting part of it, the abuse of a corpse and those charges, destruction of evidence. And I haven't seen anything at the trial that would suggest to me that she was somehow directly involved in ending Harmony's life. So, good question. Hi, Jim. Jammin'. Slow on the uptake tonight, guys. Can Wendy Adelson's immunity be revoked? She definitely lied. This is a good question. The question is always whether or not it's material to the case. Now, I would say that Wendy's lie about not going to the scene of the crime and not seeing the police cars is a material fact. It's clear that that the police who were there say they saw her pull up and do a three-point turn and drive away. And her testimony at Charlie's trial was, oh, no, I saw that the road was blocked off at the corner. I never went around the curve to where Dan Markel's house was. I didn't know that the police cars were outside Dan's home, and I turned around and left. That's absurd on so many levels. If you're driving down the street and there's a police lineup, a police blockade, and you know that your children live down that street, you're going to be getting through there, whatever you need to do to find out if your kids are okay. So, I mean, it's just wrong on so many levels. The question is whether the prosecutors can make better use of Wendy with immunity than revoking it. I mean, I think they will revoke her immunity if they think it will give them leverage in Donna's case. On the other hand, if they feel like they can get out of her what they need, because she's already testified at 2 different trials, if they feel they can get out of her what they need and leave the immunity in place, they're going to let her dig her own, they're going to let her dig herself in deeper, because every time she testifies just a little bit differently, and it very well could be that she's lying about material facts. So I think they probably could revoke her immunity, but I think that's a tactical decision the prosecution's going to make. And Georgia Kappelman is really smart, and she knows this case cold. And she and her co-counsel are going to weigh all of the pluses and minuses, because they have been very methodical about the case. And I think that every time a pin goes down, they're closer to Wendy. And I think that I think that if they believe once they are done with Donna, they can prosecute Wendy, they will. I think the case against Wendy is the least strong at this point, but they are continuing to investigate and continuing to look for reasons to prosecute her. So, yeah. And Charlie Adelson's house just sold. I saw that today. They sold his house, so they've all got more money to throw at lawyers and to pay his new appellate attorney. So we'll see. I don't recall. What tips would you give to an attorney who has 9 days to prepare for trial? Brew a lot of pots of coffee. Whether you have 9 days or 9 months, the bones of a trial are always the same. The sort of the roadmap of the way a trial is put together is the same. The question becomes, can you round up witnesses? Can you find experts? Can you scramble and do that stuff in that limited amount of time? And the answer is no, you can't. I mean, there is simply no way, if you suddenly need an expert to reconstruct an accident scene or something, that you can get that done in 9 days. That particular case happened to be a case, it was a lot of he said, sort of conflicting witness reports. So, and it was also a case where my client had not made a statement to the police because he was pretty savvy and stood on his right to remain silent. So a lot of what I had to do was to look at the conflicting statements among the witnesses and to try and sort of pick those things apart. So the most important thing for me was for me to know the statements of all of the witnesses cold, so that I didn't have to start shuffling through things and going, wait a minute, didn't he say, and looking things up. I really had to know those facts of those witness statements, chapter and verse. And once I knew that, then I could cross-examine and say, yes, but in your statement to police, didn't you say? We saw a lot of really good preparation in that way in Crumbly. I thought Shannon Smith did a really good job in her cross-examinations because she was extremely conversant in all of those exhibits that the prosecution offered. So she would say to a witness, now the prosecution offered this, didn't you say this? She was able to pull out the conflicting information in statements. So that's a lot of what I had to do, particularly in that trial. And it was a lot of comparing witnesses' statements and a lot of conflicting statements. That particular case didn't require an expert witness, and it was a serious assault case. And so it relied a lot on the testimony of a couple of medical witnesses who testified about the condition of the victim. And, so I was able to look at those reports and sort of go through the reports and sort of ask questions about, are you certain that this was the mechanism of that injury? Could it have been some other cause of whatever injury? So in that regard, that case, the cross-examination was pretty straightforward, but it isn't always that way. And I mean, I can't imagine in Sarah Boon's case that it's going to be as simple as that. And so it'll be interesting to see whether or not the judge forces her to go forward to trial, or whether he once again grants her a continuance. These are good questions. Anything new on Karen Reed? I think you're right. I think it is R-E-A-D. Not sure of the spelling. I haven't heard much recently about Karen Reed's case. There's still an awful lot of people out in the internets who are very firmly convinced that Karen Reed is innocent, and really have a lot of proof from the documents that back it up. So it's unfortunate that I think we've gotten off in a bit of a tangent with this YouTube creator guy who goes by the name Turtle Boy, and he's adamantly believes that she is innocent, and he has created probably more trouble than he's actually helped. He's been out protesting, and there's some discussion about whether or not he was responsible for, I think he's been charged with witness tampering for harassing witnesses. And now there's some claim that he's been communicating directly with Karen Reed, and that it may implicate her in witness tampering as well. So, and it's such a secondary issue. So it's hard because it's a distraction from what they really need to be doing. But I think that there is a very good chance that that she's innocent. I think there is a very good chance that they can raise enough reasonable doubt that she may not be convicted. Somebody wants to see my earrings. I'm going to lean forward and show you my earrings. Let's see here. They are lacquered Chinese rice paper with Chinese symbols on them. It's actually, they were given to me by my very best friend, and they actually are a Chinese poem in Chinese characters. And there's a couple little beads of jet and a pearl. They're just really, really different, and I love different jewelry. I'm a real sucker for things that not everybody has. So I love different jewelry. So, and she knows it, and she does too. So we've given each other a lot of really unique pieces over the years, and these are some of my favorites. They're according to the information that came with them, the Chinese characters are a friendship poem. So they're really special to me. And she lives in Bend. So I'm really looking forward to our move back to Bend this year, because I'm looking forward to being able to get back to being able to see her every week. She's a teacher, although she's retiring this year. And so I'm looking forward to being back and seeing old friends. And the break has been really good, because I'm not sure that I could have really retired from practice, knowing how in demand defense attorneys are these days. I think it would have been really hard for me to see my colleagues struggling under the caseloads and not say, oh, well, I'll just take a case or two. And I really needed to be done. I needed, for my own mental health, I needed to be done. So I'm looking at some new possibilities now that we're moving back to Bend, and I'm excited about new opportunities. And certainly we have a book to finish and launch. I had a conversation with my editor, my publisher editor, a couple of days ago, and they're doing their final sales presentations this week. My publisher, Pegasus Books, is an independent publisher. They're not an imprint, but they do all of their marketing and their distribution through Simon & Schuster. So they were having a marketing meeting with Simon & Schuster this week to present their fall catalog, including Children of Darkness and Light. And so things are moving on apace. We will have a live pre-order link pretty soon, I think before May, but absolutely by the time CRIMECON starts in May. And we will be charging ahead with that and doing some book signings and looking to future projects. So I'm just starting to think about what my next project might be. So, but until then, you're stuck with me on True Crime Wednesdays. So I don't plan on going anywhere. Hi, Jill Argus. How do you think Richard Allen will do in a trial? I think Richard Allen is very fragile. I think he's emotionally and physically pretty fragile. I think everything we've seen backs that up. And so I don't know. I think he has two attorneys that he has a tremendous amount of confidence in. And so I think that when a person goes to a trial, if they have confidence in their lawyers, that makes sitting through trial much easier. It makes it more comfortable. It's not comfortable. I mean, it's nerve-wracking and it's hell. But I think when you're sitting next to a lawyer who believes in you and is empathetic and who you trust, I think that makes it somewhat easier. So I think that he would navigate a trial okay. But I think it will be very unfortunate if he has to go to trial. And I do think that his attorneys have raised reasonable doubt over and over again. And I think that any other judge besides Judge Gull would have granted them hearings. I think it was foolish on her part not to have hearings on the Franks motion, on the motions in limine, all of those motions. I mean, the way that you make your appellate record is you have a hearing and you let the chips fall where they may. You don't deny people their due process and then say, oh, no harm, no foul. So it's a very unfortunate case. And just when you think it can't get any stranger, you think it can't get any more suspicious, it does. So. Shanna Gardner case looks interesting. Yeah. It's another murder for hire case. There's a couple of them out there right now. And I think what has attracted a lot of attention is the fact that the husband was a Microsoft guy and, was a rich guy. So, but, I don't, those kind of folks sometimes live in houses of cards too. So, yeah, I know I haven't followed it as closely as I followed Corey Richins. But if that's one that you all would like me, because I think her trial's coming up, if you would like me to follow it, we can. So let me know. I don't know that there are huge issues in that case. Lori, has anyone ever told you that you look a bit like Mariska Hargitay, the actress from Law and Order SUV? Oh, no, thank you. No, and I have to tell you that I'm not a big fan of those kind of shows. I had a darling neighbor who was she was an emergency room nurse, and she was a level 1 trauma nurse. And I mean, we all called her Nurse 911. She was always right in the throes of everything. In fact, one of my funny stories is she was our next door neighbor, and my husband and I, for quite a while, were involved with a group that did a lot of whitewater rafting in the Northwest. And they had a whitewater rafting trip planned, and I couldn't go because I was expecting our daughter. But my husband and the neighbor and a bunch of our friends all went on this rafting trip. So that morning they were getting ready to leave, and I said, now take good care of these guys. And she turned around and said, oh, don't worry. I got my EpiPen. I got my suture kit. I got my crash bag. And I'm like, oh boy, I thought I was just telling you to have them wear sunscreen, you know? So she was a big fan of all those TV shows, and she would come over and drink a glass of wine and say, what do you think about this? What do you think about that? And I would always say, I never watch them because they make me too crazy. So, oh, now I know who you're talking about. Tennis Girl 101, Jane Mansfield's daughter. Huh, interesting. Well, thank you. That's a compliment. Yeah, so I'm not a big fan. I don't watch CSI or LA Law or Boston Legal or any of those because I just end up, or any of the legal procedurals, because I just end up screaming at the TV, you can't do that. So that's not the right objection. So, and it makes my husband crazy. So, and we don't watch fighter pilot movies with him either, because that makes him crazy, because he will sit there and yell at the screen, that's not the right engine sound for a J-59. Yeah. So sometimes it doesn't pay to know too much. Debbie Biggs, thank you very much. We have turned stickers back on, and we appreciate that. Had a couple of people ask me about memberships, and I haven't gotten involved in channel memberships. So please let me know if that's something that you are interested in. I might do that down the road if it's something that you're all interested in. My understanding is if your channel offers memberships and you become a member, then you get access to special content. So right now, with the book coming out, I am going to be forming a book launch league, and the first 100 people who agree to pre-order the book and post a review will get an advanced copy of the digital advanced copy of the book and some other goodies, including some one-on-one FaceTime with me and some other things that I think we're going to try and do. And in return for posting that and posting to social media. So that's my next big project. But once the book is launched, then maybe we'll talk about channel memberships, if that's something that you all are enjoying with other creators. I see other creators are doing channel memberships. And if it's something that interests you, please post it in the chat or in the comments. Let me know. I'm hesitant to rush into those kind of things because my channel was never really intended to be a revenue stream. It was intended to be a resource for you and an opportunity for me to have a conversation with the true crime community and to bring awareness to my book. So, but let me know if that's something y'all are interested in. And thank you so much again, Debbie. Wristbands, you can still get one. I just picked up the handful of requests that I had from my P.O. box yesterday. And so I'll be dropping those out in the mail very shortly. So wristbands are still available, and I absolutely would love it if we flood social media with photos of people wearing their wristbands during Chad's trial. I want to remind everybody, CRIMECON is coming up. It is a blast if you can go. It is in Nashville, Tennessee this year. The details are in our show notes. And I know that it's not an inexpensive endeavor. Tickets are expensive. But I want to remind folks that you can volunteer. And if you volunteer, it amounts to them giving you a CRIMECON t-shirt and you directing traffic and telling people what rooms to go to for all of the seminars and sessions that happen, and answering questions, and you get a ticket for it. And you don't work the whole time. So it's worth it if you're interested. There is a link in our notes if you're interested in volunteering. And I'm excited. We're going to have a booth. We're going to be handing out swag to folks who pre-order the book and meeting and greeting. And I'm really excited about it. It's going to be great fun. Me and not a lot of other creators. And it's great fun. So if you haven't subscribed, please do. Although I haven't been very active recently because I've been busy writing the book. I haven't written a lot of newsletters. There is a huge archive. There are 2 years worth of weekly newsletters there about the Vallow case and a few other cases as well. So definitely subscribe. We have a Facebook group. It's called The Good Lori. So join us there if you would like to. Our moderator, Jen, is also the administrator for that group. And we're trying to get busier posting stuff in that. You look for some good announcements coming up. I want to thank everybody for being with us tonight. I always appreciate it. Thanks for being with me on Valentine's Day, for being my Valentines. I'm sending you all lots of love. Thanks for that. I know that you could be anywhere else. I hope you're curled up with your Valentine. I just hope that you all have a great week this week. Join us again on Wednesday, and be sure, yours is going postal tomorrow. Okay, be sure and like and subscribe, please, and hit the notification bell, because when things happen, and remember, the Daybell case is coming up in April, so we're probably going to have more of those surprise lives and shorts going on. So be sure and subscribe and hit the notifications bell so you'll get notified when those come up. I'm going to say good night. Thank you so much for joining us. As always, I appreciate everyone being here, and I will see you next week. Good night.